major Supreme Court decision on gun rights in America.
It has been a law that has been on the books in New York since 1913.
The Supreme Court has sided with them, striking down New York law.
The most significant case regarding the Second Amendment in more than a decade.
6-3 decision. The court struck down New York's law, which places restrictions on concealed handguns.
The Supreme Court has just issued a 6-3 order on the concealed carry case, and it has changed the Second Amendment fight forever. A statement on the concealed carry case by the Supreme Court stated, "The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees." And despite this statement, there are several states who have outright defied the order that the Supreme Court released in Bruin. So let's get into it and find out the latest development in the concealed carry case. But before that, make sure you're subscribed, because I'll be telling you things here that they definitely don't want you to know. Now, the matter of concealed carry is once again in the Supreme Court, mainly because states like New York and California are completely defying what the Supreme Court said in Bruin. If you remember, there were 5 different cases that had precipitated reviews, arguments, and hearings in the Second Court of Appeals. It was all because of a warning that the Supreme Court issued to the Second Circuit and the state of New York. All 5 of these cases were challenging the New York's latest Concealed Carry Improvement Act, which was also being called CCIA. The state of New York used the CCIA law to put extremely restrictive bans on concealed carry. This act was also being considered a direct reply to the Supreme Court's 6-3 decision in the Bruin, New York and New York State Rifle and Pistol Association case. The Second Circuit didn't quite listen to what the Supreme Court ruled in 6-3, and that's why you have these organizations like Gun Owners of America, who have actually requested the Supreme Court to review the Bruin case and take down the CCIA by the state of New York. They also want the Supreme Court to rule against the defiance of New York and strike down the heavy restrictions they've put on concealed carry. And not only the organizations, but also several law enforcement agencies, like the Big Sheriff's Office, are also requesting the Supreme Court to take down the CCIA law by the state of New York, because it goes against the civilians' Second Amendment rights. The Supreme Court has, in the past, taken down the New York CCW Licensing Act 2 in the Bruin case. The Supreme Court revealed that CCW licensing went against the history, tradition, and Constitution, and the states can't make up their own constitution as they please. The main decision in Bruin was that the state of New York had the responsibility to prove that the restrictions they're putting are justified, based on the history and tradition of the entire nation. And it didn't have to be a recent history, but dating as far back as 1791. However, in the final decision of this case, the Supreme Court states that states, including New York, can't just pick any location and label it as sensitive. But despite that decision not going in the state of New York's favor, they jumped the gun. So New York essentially went on and passed the Concealed Carry Improvement Act, and all this happened only 8 days after the decision in the Bruin case was issued. And to the state of New York's surprise, this law was immediately challenged in several district courts, and a lot of these cases were given a preliminary injunction. These injunctions stopped the CCA law from being enforced in the state to its entirety. So, the state of New York appealed against these preliminary injunctions in the Second Circuit, because so far, the cases were tarnishing the reputation of their new act. The New York authorities went ahead and appealed, after which, the Second Circuit gave stays in multiple CCIA cases that were in progress in the lower court. As a response, GOA also went for an emergency review and submitted an emergency application to the Supreme Court. The senior vice president of GOA, Eric Pratt, said in his statement, "New York politicians just couldn't help themselves when they quickly doubled down with their unconstitutional edicts following the Bruin decision. I'm incredibly confident the justices will take an extra look at this case, since their previous ruling was ignored by the insubordinate tyrants in Albany." Sam Parades from Gun Owners Foundation added, "We sent the warning out to politicians far and wide following Bruin. Fall in line or we will make you." Sadly, New York refused to honor the Constitution, so we have no choice but to follow through on our threat. We urge the court to take the case and once again rebuke New York's unconstitutional gun control. So the Supreme Court finally reviewed their emergency application and denied relief. but the order also stated that the Second Circuit cannot just be lazy on this issue. And with the Supreme Court's order, expedited hearings were arranged in all the CCIA cases. So the Second Circuit listened to all these cases, ruled in all 5 of them, and the ruling was: the Second Circuit ultimately vacated some of the district court's injunction against the enforcement of the CCIA, siding with the state of New York. The Second Circuit also presented the Bruen case as an exception, and they simply vacated the majority of injunctions in the district court by simply finding ways to declare CCIA constitutional under the Second Amendment. So the Second Circuit found that the CCIA is constitutional while reviewing the concealed carry case that the state of New York tried to enforce only 8 days after the Bruen case decision. And it baffles me that the Second Circuit is trying to prove that the Bruen case is different from CCIA, and its decision doesn't apply here. This argument simply doesn't make any sense to me, at least, and this doesn't make any sense to GOA either, which is why they're now filing a petition in the Supreme Court to review the decision made by the Second Circuit. Although the case is in its early stages, I think it was a good idea to take it to the Supreme Court, because it links directly with the Supreme Court's Bruen decision, which was issued only 8 days before this act was passed. The Supreme Court has also previously said in the emergency petition that there's always a potential for reconsideration if the parties are not justified with the Second Circuit's decision. So this makes the case a perfect fit for the Supreme Court. GOA has pointed out in their petition that the Second Circuit, with other lower courts, are now openly going against the Supreme Court and its decision in the Bruen case. GOA also pointed out that throughout the case, the Second Circuit panel kept highlighting that they are not really bound to apply the same methods that the Supreme Court applied in the Bruen case. So they basically turned the Bruen case into an exception. The Second Circuit also said that any court is not bound to follow the Bruen's decision in upcoming cases, especially when dealing with less exceptional regulations. GOA revealed that the panel repeated these things at least 4 times, each time making it seem like the Bruen framework was only relevant to that case, and the Supreme Court reached that decision because the case was an exception. The GOA is trying to show the Supreme Court that the lower courts are truly defying its decision, and the decision of the Supreme Court in this case will determine the future of the Second Amendment, not just in New York, but also in states like California and Colorado. If you don't know it yet, the state of California is also going through very similar concealed carry restrictions under the SB 4 law. CRPA has already filed a lawsuit against the SB 2 law, and there are a lot of plaintiffs that are opposing these restrictions and are part of the law. The case is being built around historic evidence and tradition, so the Ninth Circuit will have to figure out if these extreme restrictions were ever in the ideology or constitution of the US. So any decision in the New York's CCIA case will obviously be used by the Ninth Circuit, because these decisions have very far-reaching implications. This is the reason why massive organizations like CRPA are filing lawsuits, and even the big law enforcement agencies are also going against these laws in California and New York and extending their support to GOA. They want the Supreme Court to review this case and eventually strike down the CCIA by the state of New York. The New York Sheriff's Office wrote in their brief to the Supreme Court, "The Second Circuit stay ruling in the above captioned proceeding is at odds with both Heller and Bruen's established precedents. New York State's Concealed Carry Improvement Act, passed hastily in the wake of Bruen, requires that pistol license applicants possess the requisite good moral character for licensure. An amorphous standard that seems little different from the proper cause standard that was found to be unconstitutional in Bruen. So, the New York Sheriff's Association won't really let the state of New York get away with this act. In California, there's also an organization called the Peace Officers Research Association, also sent a brief to the Supreme Court and requested a review in this case. They wrote in their brief, "Laws such as SB 2 and CCIA encourage gun violence by constricting self-defense options and reducing the risks to criminals. This court's intervention is necessary to correct the Second Circuit's error in overly broadly defining the categories of acceptable analogs, thereby eviscerating any meaningful right to bear arms. Although purportedly intended to protect vulnerable people, these laws actually subject them to greater risks of gun violence." So, by the looks of it, I think this case is going to destroy the reputation of the state of New York. and it's definitely not going to end well for them. Because when you have organizations and law enforcement agencies like Highway Patrol and the Sheriff's Office against you, you gotta review your decision. All the law enforcement agencies are saying that the concealed carry acts passed after the Bruin are doing more harm than good, and they won't really do anything to reduce crime. In fact, they'll reduce the chance of survival for the victims. CRPA also released a brief in which they explained that the Second Circuit's analysis of the Bruin case is completely wrong, and they didn't really apply it properly in the Antonuck case. It also pointed out that the lower courts are coming up with two-step tests to reach a decision, while previously, these same courts declared that a two-step approach was not right in the Bruin case. So, if you're wondering what all this mess actually means, well, it just means that the CCIA case is now a very strong case and could be reviewed by the Supreme Court. And also keeping in mind that the Supreme Court declared certain restrictions unconstitutional under the Second Amendment in the Bruin case, and the state of New York still went on and passed the CCA Act, putting the most extreme restrictions on the masses. The Second Circuit's proceedings so far are going completely against the Bruin decision, and the New York's response will be taken on May 9th. So it will be very interesting to see how New York will justify the act, and how they'll make everyone believe that the act doesn't go against the Second Amendment, and will actually help in reducing crime. So, we'll see how it all plays out, and if you want to stay updated with this extremely important case, then make sure that you're subscribed to my channel. Also, do you think the Supreme Court will review and order a 6-3 in this case too? Drop a comment and let us know. And don't forget to like and share. We'll see you in the next video. Till then, take care and thanks for watching.